any actions against them unless it's in the arbitration clause, because that was what was agreed to. It's all about contract law and understanding that you got to go by what you signed. So we're going to make them do that.
Perfect. Thank you, nephew. I appreciate it. So,
Of course.
okay, it's 7:15. We're gonna go ahead and get started. As you guys see, hold on 1 second. Let me do something real quick. We are not recording. So, last class that we had, which was on the 10th of January, it was about arbitration. As I told you guys before, and I will tell you again, and I was screaming from the mountaintops, that if you want true remedy, and I mean true remedy, where you don't have to send another letter, where you know every month that when you get that statement in the mail that it says 0 on it, blah, 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 the whole 9 yards, you have to do what the contract says. I don't know how many of you guys took the time to read your contract. I said you might want to read it because the answers are there. Everybody. And when I say everybody, including Experian, TransUnion, and Equifax, they all have an arbitration agreement. Student loans, arbitration agreement. So as I said before, and I will say it again, before you guys attempt to go read a law, read your contract. It's contract. Read your contract. The answer is inside of your contract. But I will tell you about arbitration, though. Arbitration is not for the faint at heart. Arbitration has no appeal process. And going into arbitration, talking about 18 USC that the government is supposed to pay my bills, you're going to lose. Just like I broke down that contract in the last class. Oh, I'll address that too. Why did I not give out the replay of the last class yet? Because if I would have, y'all would have jumped around here going on AmericanAssociation.org trying to put in an arbitration, and you have no clue of what it is that you're doing, and then you're going to expect Tamika or Caleb to fix it, and I will not unless you book me to do it. So that's why I did not give up the video. Yet it is a 2-part class, so you'll get the both of them at the same time. There was no point. I already know I've been doing this long enough to know you guys are going to immediately read one line and you were going to jump into something that you are going to have problems with if you don't have the basic foundation. And if you can't get something off your credit report with all the information we got, you ain't winning no arbitration, period. So when this class is released, the last class will be released so that you can put both of the information together instead of 2 parts. So that's why I was not giving up. So we're gonna go back to the contract that I had up last time just so that I can show y'all something. I think that's what okay, so this is the contract that I had last week, where we were going over. For the most part, all of these contracts have this agreement in there. If it's not on your physical contract, go on their website. If you have an account with Capital One, I don't care what type of account it is that you hold within Capital One system, if they have an arbitration agreement, it is there, okay? So the reason that arbitration is so powerful and so deadly is because it deals with equity and law. If you made it this far in my class, I think you should know what equity and law is, okay? The law is not the USC, the United States Code that y'all love to regurgitate, okay? It's not that. The law is CFRs. There is a CFR on every last contract, 16 CFR 433.1 to be exact. Sorry, 0.2, the definitions is 0.1. It's there for a reason, so that's the law. That is giving you your right, okay? When you are doing an arbitration in order for you to even start arbitration. Do y'all see this area right here where it says arbitration provision? You have to immediately upload them that so that they can know that you even have an arbitration agreement in there and that you are held liable by that arbitration agreement, whether it's you or whether it's the company. It has to be there. You have to upload that to them when you do the documentation for it. Okay, that's number one. So you will find this agreement within any of your statements. And as I said, everybody has it, including your bank. It's inside of the terms and conditions or the cardholder services, but it's there. You know, it's going to take a little work for you guys that don't like to work. Yeah, get to work because it's there. They're even in mortgages. Now, the mortgage documents is a lot. The mortgage process is a little different, but there's the arbitration clause within your mortgage document. You're gonna have to dig for it and find it because there's so many papers for you guys who have houses. You know, you almost sign your life away when it comes to signing for a mortgage, okay? So you're going to find the arbitration provision. And it says either you or we. You or we. The we is the corporation. You are the you, of course, okay? Choose to have any dispute between us decided by arbitration and not in court. So for you guys that don't know, anything dealing with the contract is a security. Okay, hopefully by this time you know what a security is. If you don't, I'll recap just a little bit. Is there anything that got your social security number on there? Anything that got your John Hancock on there, okay? It's a security. Whether it is a lease contract for a home, down to a credit card contract, including the applications, okay? So either you or them can have it disputed by arbitration. So for anybody that's had a repo, you know you can get them on this because they said that they would only settle the dispute via arbitration. So how did they repo your car without arbitration hearing? So they violated their own contract, okay? So by a court or a jury trial. So now, because all securities are federal, that's what the law says. They are federal, okay? So if you're being sued by Credit One Bank and you in state court, if anybody is on this live and you are now being sued by a debt collector, put in a motion to withdraw due to arbitration clause, it would immediately move it out of state court. They can never take it back to state court. And then you are able to move it to arbitration. 9 times out of 10, they're going to drop it. State court does not have the jurisdiction or the legal capacity because they're not even a court, it's tax court, as I've said a million times, for you to even, or them to even render a judgment on you. So if anybody being sued right now by a debt collector and you have an arbitration clause, do a motion to remove due to arbitration clause held within contract. It will immediately get dismissed, okay?
And look at what it says, right? Because towards the bottom, and it literally tells you on there, any arbitration under this arbitration provision shall be governed by the Federal Arbitration Act, which is 9 U.S.C. 1, so you can go read that later, and not by any state law concerning arbitration. So one, if it's in state court, you can use the arbitration clause to be like, well, here's the proof, right? And it says, any award by the arbitrator shall be in writing and will be final and binding on all parties, subject to any limited right to appeal under the Federal Arbitration Act. So once they make a decision, 9 times out of 10, it's final, unless you have a right to appeal. But it's not supposed to be in state court, and it tells you what governs it. It's not state law, automatically federal.
Boom. Thank you, nephew. There y'all have it. So even if you have been sued and you already have a judgment against you, you can roll it up under a civil 60 fraud against the court and use that same thing that we just said to get that that case dismissed or the judgment of it overturned, okay? So just like you can use arbitration, they can use arbitration, and arbitration is the only thing that they said that they can use to have any adverse actions towards you. That sounds like a repo. That also sounds like a foreclosure. How were they able in these non-judicial states like Pennsylvania and California They're just taking people's property, but they have not went through arbitration first. Okay. So discovery and rights to appeal and arbitration are generally more limited in a lawsuit. And other rights that you would have in court may not be available in arbitration. That is so true. The things that you can do in court, the discovery that you can ask for in court, depending on what you're taking in for arbitration for, you may not be able to get it into arbitration. Hence why I said that all arbitration lawsuits are NDAs are signed, which is why people who win arbitration cases, you never hear about it because legally they cannot speak about it. And I know this is the world of social media where everybody like to show their life and lives that ain't even theirs either. You know, you'll be in real trouble. You win an arbitration and then they see you post about it because then they have the right to come back and take those funds from you. And as nephew said, arbitrations, you cannot appeal and you cannot, because if all securities are federal, arbitration is federal and it's equity and law. If you lose, that's it. So don't go on arbitration, talk about the United States supposed to pay my bills, you're going to lose. Point blank, period. You have to know contract law, which we went over the contract in the last class. I showed you everything that was wrong with the contract. Okay. So it tells you on this agreement exactly where you are supposed to go. But it also says you may choose the arbitration company. You do not have to use American Arbitration Association. You do have a right to choose whatever arbitration company you want. You have the right to hire your own arbitrary hearing officer. Those are the rights that you have, which is why they use the word may choose. May choose is the operative words in this statement, which is why it's very important that you read everything. Now, if you did not want the arbitration clause to be, to have to abide by it, you had 30 or 60 days, depending on your contract, on how to waive arbitration. Okay, so for you guys who have ever done a class action lawsuit, I guarantee you didn't read it. Okay, because it'll tell you if you accept the class action lawsuit and get the 10 cents that they like to send you because everybody and their mama didn't apply for it, you cannot come back and sue them. And here it is. You expressively waive any right you may have to arbitrate a class action. Because at any time you can start a class action lawsuit against these people. The one who filed to get paid the most, but the lawyer is going to walk away more than everything. So it's best to take them into arbitration, and from arbitration, get the remedy on which it is that you seek. Okay. So arbitrators shall be attorneys or retired judges, and they are normally federal judges that are the arbitrators. And sometimes they are attorneys as well. When you go through the arbitration process, each party has to provide their resume. So you'll know exactly who they are. Okay. It also lets you know that it should be conducted in the federal jurisdiction in which you reside, unless the seller creditor is, hold on, I gotta move this thing. Okay. Unless the seller creditor is a party to the claim or the dispute. So whatever state that you're in is where you will file the arbitration. Okay, so it does say we will pay. So now within this particular contract, because you do have to spend some money at some point. I know y'all don't really like them to, but yeah, you have to. But in this case with the arbitration, only because her contract said it, your contract may not say, we will pay your filing, administration service or case management fee and your arbitrator or hearing fee up to a maximum of $5,000, unless the law or the rules of the Trojan Arbitration Organization requires them to pay more. So when you do a filing for arbitration and you file the documentation, the arbitrator sends it over to the particular company. Now, I know people that are on this live that you have sent affidavits and you guys have sent other things and they never respond to you because you didn't do it right. Not that the paperwork that you turned in right, because it very well could be, but because you did not do it through arbitration. Now, anything that you ask for, any documentary evidence that you ask for while you're doing arbitration, guess what? They have to give it. All of it. So if you're dealing with a car, I would not just ask for my contract. And if y'all was y'all, I would have an ink pen, because if you are dealing with the car, not only are you going to ask for the original contract, you're going to ask them for the purchase order and the bill of sale. Because the purchase order will show you that it was a negative number at the bottom of what they said that you owed them, instead of the positive number on the fake documentation that they gave you to sign. So the company will put the cost of the arbitration, which they'll pay the filing, the administration service, or case management fee. So the case management fee will be if you hired a consultant or an attorney to handle your case for you, that fee can be refunded to you if you win, because they have to pay up to a maximum of $5,000 for those services. Okay, now if you got something you want to say?
You good.
Okay, so that's that. But further down in her contract, it say you or we retain the right to seek remedies in small claims court for disputes or claims within that court's jurisdiction. Well, we already know that they don't have no jurisdiction, because it is a security, and under Title 12, all securities are automatic federal. Okay. Now, there is a part that's on your contract, the one that says under law 16 CFR 433.2, that says any holder of this consumer credit contract can assert their rights. Right? The debtor can assert their rights to anybody that's holding this contract. Do you understand that the application was a contract? Do you understand that your application can be transferred to a third party? So you know how when you go get a car, they run your credit through 15 different people. Guess what? You can add all 15 of them people to your arbitration thing, because why? They all are holding a contract. When you do your arbitration, please do not just put the car dealership. Put whoever they trustee, their indentured trustee, in every part, as I've showed you guys under SPG Global, how to track the way that your note is moving. So let's say it went through Audi Financial LLC and they transferred it to Audi Trust LLC. Guess who all need to be on that paper? Every last single company or organization, whether it's the same one, but it's a different name, needs to be added to the arbitration clause if you want it to be sufficient. Please, once again, don't talk about nothing that all debts is paid, because it has nothing to do with that. What it has to do with is the fact that you signed a contract saying that you will pay something, but the contract is fraud, because only a contract can exist in between the seller creditor, and the finance company. We learned that in the last class. So where did we come in at? Once again, where are we in this equation? Outside of the fact under 16 CFR 444.2, we co-sign for the dealership to get the loan. So yes, would you also add the dealership? Because the dealership, they are credit arrangers, okay? Let me say it again. The role of the dealership, they are there to arrange credit. And that's what they do, unless you come in there with your own financing. That's why they run yourself through 15 different people. And whatever interest rate is best for them, because you are co-signing for them, that's what you want to go to. But if they gave your application to 15 different finance companies, you can add all of them on to your arbitration clause and make all of them pay you, because they are now making money off of your security, which was the contract as well as the application. And I don't know if I showed y'all already, but I think I have, like in the beginning, that they sold one contract 10,000 times. So they've been overpaid, triple paid, and overpaid, paid again, paid enough for the world off of one contract. Okay, so. When it comes to these contracts, and they're one-party contracts, if you look, and this same statement is on you guys' contract, how this contract can be changed. This contract contains the entire agreement between you and us relating to this contract. Any change to this contract must be in writing and we must sign. No oral changes are binding, which is why I tell y'all, stop calling y'all credit card companies. Stop calling these card people. Anything that you're saying makes no sense to them. It's not binding to them. Okay. And remember, corporations can't speak. So you went in there as a corporation because you went in there as your all caps name. You just went in there as the agent for the corporation. So it doesn't work. But let me back up one more time up here. Let me highlight this because I want y'all to pay attention to this. For y'all who done got repo, oh, it's not going to highlight for me. Where it says, neither you nor we waive the right to arbitrate by using self-help remedies, such as repossession. I'll leave that there. Go find it in your contract, is there, and understand what they really just said right there. Okay, self-help remedies. Self-help remedies such as repossession. They put it in there that they can't repossess from you. But hey, you signed it. But anyway, when it comes to changing the contract, you have 30 days to change this contract. You could have changed this contract to anything that you wanted, because if you look at it, the only person name on here is the buyers. You don't see no other signature on there, do you? It's only the buyers. Where's the rest of the people?
This is when you have your pen and you start crossing stuff out and initialing, right? You see, but that's a different story.
You can change the entire contract. I did it with a court case. Somebody got a plea. They had a plea deal, right? I changed the entire plea deal because they say, you know, read this and sign this if you accept. So we countered. Like, you can counter these people. You understand what I'm saying? Regardless, because you are the only signature, because in order for you to have a contract, any kind of contract, I don't care what it is, it takes two people. Where is the second person on this contract? Do y'all see it? I don't see it. Y'all never noticed too that it says that your annual percentage rate can be negotiated. Y'all just take whatever they get you. Please, y'all, start reading this contract. Okay? And also know that it's not just the consumer contract you can get a copy of. You want the purchase order, you want the bill of sale, and you want the consumer credit contract, because they're not the same. So y'all that's trying to get it, that's what you need to be asking for. And we know that they don't like to give you anything. But one surefire way you gonna get it is if you do it through the arbitration process. They have to give it. Whatever you ask them for, they have to give, okay? So, like, this is so sad, y'all, because I have never ran a class where I did not allow y'all to ask me a question. And it's just really hurting me not to do it, but I'm gonna be ordinary today for the first time in my 40 plus years of living. That's crazy. But anyway. Nephew, did you see the screen that says consumer arbitration rules?
Yes.
All righty. So they have different rules for, depending on if it's business. So for you guys that have businesses in here, you got arbitration clause in your business contracts. Yes, you can do arbitration for your businesses, okay? But since we're only talking about the consumer arbitration rules, these are the rules that you must abide by, okay? This is through the American Arbitration Association. There's no better way to get the information than to get it from them, okay? So we're gonna break this down just a little bit. I ain't going through all of it. Y'all want to find it, Google it. Because I'm ordinary, so I'm just not gonna be giving away stuff. So as we see, the arbitration, the American Arbitration Association, which is the AAA, applies to the consumer arbitration rules. And that is in parentheses. So I might, if I was you, I would go see why did they highlight the word rules. I could tell you, but do a little work. To the arbitration clauses and agreements between an individual consumer and businesses where the business has a standardized, I'll be done in a minute. Application of arbitration clauses with customers and where the terms and conditions of the purchase is standardized. That go right back to what I said. Go pull the terms and conditions. I win. I will tell y'all this. I am 20-0. So that means I've won 20. I've had 20 cases and I've lost none in arbitration. Maybe I'll put a story that don't name particular companies or something to kind of like put it together. But yeah, I'm 20-0. But I'm ordinary though. Goods or services are non-negotiable or primary non-negotiable in most of the terms, conditions, features, or choices. Okay. So that lets you know that we're in the right spot because you are the consumer. We're doing business with businesses, but there is a particular consumer due process protocol that you have to go through. This is serious, okay? When you go to arbitration, understand you are battling whatever company it is, attorneys, okay? And sometimes, like in the case that we have now, they done went from one attorney to two attorneys to three attorneys, okay? Not just that, you have to be prepared when they counter, because they're going to counter. They're going to ask that the arbitration hearing officer dismiss your case due to lack of something. They just did it to somebody today. And guess what? You have to counter what they said to make sure that they don't throw your arbitration case out. Because if they throw your arbitration case out, guess what? You can't come back. You have no other court to take them to outside of federal court. But you're not going to get an attorney to take this case like the way we're learning it, because we know that they're part of the fraud. But 15 U.S.C. 1692 clearly says that there is no attorneys, which is why you're able to use consultants and things like that in your arbitration hearings, okay? So the administrator's role is to manage the administrative aspects of the arbitration, such as the appointment of the arbitrator. So yes, they will appoint your arbitrator for you. Preliminary decisions about where the hearings may take place and the handling fees associated with the arbitration. So how this happens, guys, as soon as you do the arbitration paperwork, you are going to get a response. You will never not get a response when it comes to arbitration, because everything is going through the hearing officer. Everything has to go through the hearing officer, okay? Do not be fooled by whatever company you're taking, because what they're going to do, they are going to email you privately, okay? They're going to email you privately, and they're going to try to have an off-the-record conversation settlement with you. Don't do it. If the email did not come from your arbitration officer, just save it and use it later. Okay. When you are beginning your arbitration process, do not let the left hand know completely what the right hand is doing. Let me say it again. Do not let the left hand know completely yet the knowledge and the foundation that you have. They're going to ask you for a copy of the contract. You got lines talking about they couldn't get it. No, you want them to turn in the contract because their contract don't look like yours. If you've already done administrative processes with them, 1099 AACs or whatever you may have attempted, make sure you have that, because you're going to upload that through the arbitration portal though. So now the arbitrator got it, which means they got it, and the arbitration give them 10 days to respond. If they don't respond in 10 days, they're in default. So do not let them know everything. Just in the beginning, you can say violations of securities fraud. Leave it point blank like that. Let them start turning in their papers first, because they got to give up their resume. More importantly, they got to pay. These companies try not to pay, so that's why they try to do off-the-record conversations with you, or they will ask for extensions through the arbitration company not to pay that fee. Don't fall for it, because you're not going to, don't fall for it, guys. Okay? So the role of the administrator and the aspect of the arbitration, they'll do the appointment. They will make the preliminary decisions about where the hearings will take place. They are normally done online. They're never really in person. It will be like some type of Zoom or something of that magnitude, okay? So you don't have to go anywhere for that. And the fees that the company has to pay, the arbitration company, make sure that they collect those fees from them as well. The arbitration does not decide the merits of a case or make any rulings on issues such as what documents must be shared with each side. Do you hear that? They can't make them give you nothing. But if you have the foundation and you know the law about documentary evidence, you know what evidence to ask for by name, not let me get my file or let me just know. You better know the documents by name. This is even a time that you can ask them. Y'all heard me say a contract got sold 10,000 times, right? You can ask them during arbitration that they provide the accounting. And if I was you, I would use the accounting, the GAAP accountings at that. GAAP with 2 A's, GAAP. Because then they got to give up everything. You can ask them to provide information for everybody that is in holder as a holder of that contract. Do it through arbitration. Because it'll look really bad on that company if you request these things, the arbitrator send it to them, and then they deny you those things. They're going to look bad in front of the arbitrator. You think they want to look bad in front of a federal judge? No, they don't. I'm on a call. I'm on a call. Nephew, take over for 1 second for me.
Okay.
Thank you.
Mm-hmm.
Or somebody. You don't ask.
Basically, what she's trying to get at here is that you want to know exactly what you're looking for, and you want to hit them with the total combination of everything that we've been learning up until now, because it's about playing the game. You have to come as a sheep in wolf's clothing, or a wolf in sheep's clothing. My apologies. It's really just about playing it smart, because you are going to need to know exactly what you're looking for. Because if the people on the other side feel like even for a second that you don't know what you're talking about, then they're going to be like, okay, well, we want it to be dismissed for this reason. And if you can't counter that, then you're no better off than you were in the first place. So it's just, that's why we always push foundation, because it's really the most important thing that you can do. I strongly recommend you go read the Federal Arbitration Act, 9 U.S.C. 1, from start to finish. Read the whole thing, because that's going to be your playbook. It's going to be a lot easier to know what you can and can't ask for when you know what the arbitration rules are. And they tell you all over the place, this is the Federal Arbitration Act. Go read it. That's going to be the most important thing that you can do. Of course, understanding why it's securities fraud, understanding the fact that it says in 16 CFR 433.2 that they cannot accept any payment, partial or full, for a consumer credit contract that they got a purchase money loan. So when you go to the dealership and you get your car, you got a purchase money loan. And again, a purchase money loan, according to the definitions in 433.1, is supposed to be money that goes to you. And then again, it would go, you would transfer it to the dealership, but you're supposed to get a check. So you're supposed to get the money and the car, but you assign them security interest in the contract and you agree to it, right? So that's why they have the option for you to appeal, because technically it's illegal. And that's why it even said on there on the contract, by signing this, you agree that you've read it, you've had time to review it, and you accept. Most people don't know that according to contract law, exactly, you can rebut and you can challenge their presumptions. You can amend the contract. So that's why, again, you take your pen, you cross it out, and you initial any parts that you don't agree with, right? And then they have the option to, again, rebut again until you reach a final agreement. So that's pretty much all it comes down to, is having a solid foundation, because when you go file for arbitration, you need to know exactly what type of securities fraud and why they defrauded you in the first place. And you have to make a case to defend yourself, because unfortunately the burden of proof is going to be on you, because they're going to say that you signed it. But because they have rules that they're bound by, the stronger that your case is, the less likely they are to dismiss. And that's really all you can do. But it is a more intense process because, again, you're going up against actual attorneys. Um, and depending on the process that you're doing, depending on what you've done, it's going to either make it easier or make it harder for you. If you have foundation in other areas, like for those of you who are doing your billing disputes right now, it's going to be a similar type of situation because, and that's why I was saying when you go and initially file your billing dispute, don't give them everything, because if you come out the gate with everything, well, then they already know what you're doing. So they'll find every single reason in the book for them to shoot down what you're saying. That doesn't apply to us. It's our part. I mean, and honestly, there's been times where I've heard them say things to people that are just straight up a lie or are not true, and the person will just accept it because they don't know any better. So that's why I really push understanding, because if you don't know how to build your own house, like I said, when your house crumbles, you're not going to be in a position to build another one if somebody else builds it for you. So as long as you can, and I know it can be a little difficult, but give yourself breaks. I know we're running out of time and they want to make it seem like, we're going to run into some sort of financial disaster. But again, that is for people who are just going about their lives. People who understand that this country runs on debt and it runs on credit, that they'll never run out because they have to extend the limit, or they're using it as a front in order to flip the currency, make a disaster. You see what I'm saying? Their entire job is to incite fear. Don't be worried. You have all the time in the world, and the timing is going to work out when it needs to work out. Things don't always happen when we want them to happen, but when we need them to happen. And that's one thing that I've had to come to terms with and accept on this process, is that, I'm not, you might be looking for one thing, but you're not ready for it. Um, and when you get to you're finally going to get to a point where you're like, I have such an understanding that, like, it makes sense. Like when you see things, something new that you've never read, you have an understanding of it, and it's sounding less and less like a foreign language. So you're going to get to that point, but it's all about timing. And I know it seems like we're doing a lot of waiting, but it's like there's only so much that you can really do. Even if you sat at home for a week straight with nothing to do, you would only be able to accomplish so much before you burn yourself out mentally and physically. So you have to pace yourself, because that's another issue that people run into, is that they go too hard. They try something and they get discouraged because they didn't do it right, or they didn't have all of the foundation. And that's really the main thing that you see happen all the time. Um, but that's pretty much all I got to say on that. If we're gonna keep going, once she gets back, because
I'm back.
okay, perfect, right on time.
Hey, I'm back. Thank you so much, nephew. So yeah, like he said, I don't know, everybody in just is such a rush, and it's like, how many people, and y'all can raise your hand, but you put it back down when you're done. Actually took the time after the last arbitration clause to even look at your contract to see if you had an arbitration agreement in there. Actually took the time to go and pull the federal arbitration law and the whole 9 yards, because you have to know it. I say even with, let's see, 27. You're going to against the attorneys. So you have to know it. And so there's almost 300 people on this call and only 33 people raised their hand, but y'all be in such a rush. Tamika. Where's the link? Like everybody on this class know the link come out the day before, well, the day of. Why? Because I have to protect my link. You got to register for the class. Like nothing has changed. So there's 38 people who actually took the time to really go look at those laws. And it's all my same people that is walking around here with almost 800 credit scores right now because they listen to what Tamika says. So are you hoarding information for no reason? Because you're never going to know if the information works unless you put it to the test. You're not going to gain foundation unless you put it to the test.
And also, along with that, what I want to say is, how many of you are waiting on replays, or again, waiting on the back office, when there's a lot of people who without those things have taken the same videos that you still have access to most of the videos. So you go back and watch them and you have all the information that you need in order to take an action. But if you're just sitting on the information, it's of no benefit to you. You have to, but also, if you feel like you don't have the understanding to try something, that means that you need to study more, because it's there. People with the same resources that you have accomplished what you're trying to do. So you have to change your focus. It's not about asking questions. The questions are answered. A lot of times, a lot of the questions that we get asked have been answered, or it simply takes critical thinking. And that's where foundation comes in, because if you have a sort of foundation, you got to use your own, you got to sort of think in certain situations and put two and two together. If you can't read between the lines, it's going to be a lot more difficult for you, because there's a lot of double speak in contract law and in law in general. So that's all you got to do.
He is absolutely correct. Like, the point, do you know how easy it would be for me to just to develop a whole bunch of templates and throw them at y'all? That will be easier for my energy. Cause see, I believe this. Like, I have done the work for y'all, the work that y'all won't do. When I say for 11 years I've been reading, I mean every single day. There's not a day that go by that I do not read. Okay? Not one day. And to even strengthen what I've already have by self-knowledge, to make sure that I can help the people, I took my old ass back to school for y'all. So now I'm self-taught. Now let me get one of their pieces of paper to say that I'm is what it is. The class is supposed to be 7 weeks long, and I'm almost done with it because I have the foundation that I ain't even have to read it. I went straight to the quiz. I said, let me quiz my own self. I went to the little welcome thing because I had to, but after I jumped all the way to the end of the class, I said, let me go see what I know. Let me see if it's something that I'm missing. Because I know, and I'm telling y'all, your remedy is an arbitration. You want your account open-ended? Arbitration. You want to get back your down payment plus all of your payments and the amount of the contract? Like, I'm probably the only one that tell y'all the finance charge the total sum of the entire contract. So now they didn't violate a TILA though. So now that's times 2.
The sum of all payments, 1605. Y'all need to read Truth in Lending. See, you need to read all of the Consumer Protection Acts. You need to go onto the CFPB website under their consumer education and under Regulation P, protection of consumers. You need to read all them CFRs, because they got everything that you're looking for.
Absolutely. Now, last week there were some questions that was asked, but I told you, as far as if you did a buy here, pay here, yeah, you could take them to arbitration. They changed it. And if you go up under the CFPB and search buy here, pay here lots, you'll see a whole bunch of lawsuits that the CFPB have done against these buy here, pay here lots. So if that's your issue, there's your remedy. But we know that with under TILA, you got 3 years to go back on now. But not if you got an arbitration agreement, because I told you they changed the arbitration rules starting this year. Your arbitration agreement outlives the contract. So what do I mean by that? This could be a contract you had 5 years ago, everything is paid off in the whole 9 yards. It could be a car that you already paid off, or something that you paid off, a Kroll's credit card or whatever. If there's an arbitration agreement in there, you can still take them to arbitration. There is no time limit on arbitration. But you know why there's no time limit on arbitration? Because the law says, the law, not a code, says that there is no time frame on fraud. Y'all see how all this tie back into arbitration? So yes, it can be an old contract. This is why they tell you to keep your documents for 7 years. So you can prove that you had a contract with these people. And yes, you can go back and get them, because there's no statute of limitations on fraud. And this is how you get it. You take it to state court, they're going to say it's passed for 3 years. You take it to federal court, they're going to say it's passed for 3 years. You take it to arbitration, baby, they're going to be like, let's roll.
And it also says on most arbitration provisions that this provision will outlast the life of the contract, and it survives all transfers, sales, whatever happened to that contract. It don't matter if it's destroyed, and 100 years later you could go back because that arbitration clause outlived that contract in every way, shape, or form. And it says it on most of them.
It says, now go back to what you just said, nephew. Didn't you just say that it survives any transfers? What do they do with our contract? They transfer it from one company
Tell them
to
to
the next company
everybody.
to the next. And so that's why I said in the beginning of this call that everybody who's touched that contract, you can take to arbitration. Want to know everybody that touched it? Ask it under the documentary evidence that you're going to ask for when you get to that part of your case. Okay. You got something else you want to say, nephew, before I continue?
No, just again that they say it on there. It survives all sales and transfers, and it survives. So when they are moving it between all of them companies and they all touching it and holding it, just basically that again. That's all.
Yeah. So that's everybody. So, except where the parties to a case reach their own settlement, the arbitrator will make the final binding decision called the award on the dispute and render it in writing. The arbitrator make all procedural decisions on the case not made by the administrator or not decided jointly by the parties. The arbitrator may grant any relief, remedy, or outcome that the parties could have received in court, including awards of attorney fees and costs, in accordance with the laws or laws that apply to the case. So what that means is those people that I've done arbitration clause cases for, they pay a fee, I take their case, I win their case. Whatever it is they pay me, I get it back to you when I make them pay you. So it's like you fronting some money that you're gonna get a hell of a return back on. Because when I go at them, I'm asking for everything. Or I tell them, see, I know, yes, they do say that it is binding, whatever decision that they make, but there's always a loophole in everything. And due to the fact that it's security fraud and they have violated their security agreement on file with the Security Exchange, I know that I can take it to the SEC and have them handle it. And that's the last thing that a company wants, because at that point, somebody going to jail because they violated the contract. Okay. Except where parties to a case reach their own settlement. So what happens during arbitration, there's going to become a part where all the papers that's been in, the arbitrator is going to look over it, but they're going to say, can you guys mediate on your own? Normally. And out of the 20 cases, 18, only 2 of them, we didn't reach their agreement through mediation. And I still won. And then at that point, I got more for my client. Because we could have just did it through me. They wanted to play hardball. So I play hardball back. Because see, I don't have to read off a screen when I go out there. I ain't got to say, I'm next. Okay. And then on the point that you don't reach it during mediation, which an NDA will be signed, they're going to make you sign a non-disclosure agreement. At the point that it has to go in front of the arbitration administrator, now it's on the record. Even though it's admissible in court, it could be found through discovery, which means research. Okay. The arbitrators, they are neutral and they are independent decision makers who are not employees of the AAA. Once appointed to a case, an arbitrator may not be removed by one party without the other party's consent, or unless the administrator determines an arbitrator should be removed and replaced by another arbitrator chosen by the administrator in the manual described in these rules. Okay. So the AAA has developed the consumer arbitration rules for consumers and businesses that have their disagreements resolved through arbitration. Mediation in consumer disputes is also available to help parties resolve their disputes. Now, even when it comes to the dispute process, because you have done, when you do mediation, because you have chosen to do arbitration, there are certain systems and portals, what I will show you guys, that everything that you see in has to go through there. Even if the attorney send you an off the record conversation, always tag your mediator Your administrator, always tag them in the email because they would, conveniently forget to tag them in there because you want everything documented. Okay. The association charges a fee for the services under the rules, and fee schedule is included at the end of the rules and the cost of arbitration section. As I said before, for you guys that don't like to spend money in the beginning, that company has to pay these arbitration fees up to $5,000 in order to get started. Okay, arbitrators are paid for their time in resolving the disputes. Here we go again. As I said, the business makes deposits as outlined in the fee schedule. So when y'all see this fee schedule, remember I said they are to pay it. Okay, they are to pay it. Here it is while I was stating to you guys about any conversations or anything or any settlements that you guys are going to do. You have to do it 30 days prior to the planned effective date of the program. So what that means is, let's just say your hearing is scheduled for March the 9th. You have up until February the 9th to come up with agreement on your own. If you don't come up with agreement on your own and you upload that to your arbitration portal, then you guys are going to go ahead and go through the full arbitration with the mediator and you and these companies' attorneys, because it's going to be their attorneys. They ain't going to be it's going to be their attorneys. Okay. So that's that. Filing a case. This is how you initially file your case, and here are the administrative steps that you have to take in order to do so. You cannot miss one step, not one. Okay, the party should have made the consumer arbitration rules a part of their arbitration agreement whenever they have provided for arbitration by the American Arbitration Association. Now, y'all notice on that last contract, I showed you this is the company that they had down. As I said, you don't have to use them, but I just think that is wise that you do. They're very impartial and they make sure that things are handled properly. Where I stated that you have to upload to them that you have an arbitration agreement. It's right there. The arbitration agreement is contained within a consumer agreement defined below that does not specify a particular set of rules. And it don't, outside of the fact that they said that they're not supposed to do any self-help, but it's just the arbitration agreement. It also says in that particular agreement that they will pay. I have not seen one contract yet that says that the consumer will have to pay for the initial arbitration fees, okay? The arbitration agreement is contained within a consumer agreement as defined below. It specifies a particular set of rules other than the consumer arbitration rules. When parties have provided the AAA rules or AAA administration as part of their consumer agreement, they shall be deemed to have agreed that the application of the AAA rules and administration of the consumer arbitration shall be essential term of their consumer agreement. Okay, so that's just you uploading to your portal the part of your contract. You do not send them the whole contract, guys. Don't send them the whole contract. Okay, because if you notice, on most of them, the arbitration clause is in the back where you sign. Only send them the first part, because what's going to happen is they have to send whatever you send to the arbitration people, they're going to send to the opposing side. That's why I said you hold off on sending everything until you get closer to the end, right before they tell you to mediate. That's when you let it all hang out, okay? Let it hang out like you have Mardi Gras trying to get some beads, okay? Let it hang out. The AAA defines a consumer agreement as an agreement between an individual consumer and a business, where the business has a standardized symptomatic application. So here are your examples of contracts that meet the criteria for the rules. If the contract is for personal or household family services, which we know that falls up under consumer. Everything that they're supposed to be paying for falls up under household primary goods and services. As we showed on the contract, they made sure that they didn't check that, but whether they checked it or not, we know that it is so. Okay. The following: They include, but not limited to, which means, yes, it can be any other agreement outside of the ones that they name. They only name the main ones. Credit card agreements, cell phones, cable, leases, residential and automobile and manufacturer home purchase contracts, finance agreements, car loans, mortgages, bank account. Goes back to the beginning of the call when I said that every last one of your bank accounts have one. Every last one of your credit cards have one. Home inspection contracts, pest control services, moving and storage contracts. So for people who got storage facilities and things like that, and they illegally held your items for trying to offer, telling you got to pay something, yes, you can use it for that. Any other home warranties, you know how they call your phone, you need a home warranty, you need automobile warranty, that falls. Legal funding. Health and fitness membership agreements, travel services, insurance policy, private school enrollment agreements. Here are the examples of things that are normally not included. Home construction and remodeling contracts, real estate purchase and sale agreements, condominium or home association bylaws, business insurance policies. Now you see it said business insurance policy. It said nothing about an individual. Commercial loan and lease agreements. For anybody that got business, there is another process that you can do for arbitration for your commercial loans, but it is there. Commercial guarantor agreements. So these are an example. I'll give y'all a few more. Again, your student loan agreement has an arbitration clause in it. That all of the credit reporting agencies have arbitration clause in them. So for you guys who have been so wonderful with the information that I have provided, and I do appreciate every last one of you guys who have took that information and you are kissing 700 and above on your credit score. So all of those companies that was removed for a violation of the law, at this point, you want your money, take them to arbitration. You can take the company and the credit agency that listed it for violating your rights under the arbitration clause. Okay. When parties agree to arbitrate under these rules or when they provide for arbitration by the AAA, arbitration is initiated under these rules only. They thereby authorize the AAA to administer the arbitration. The authorities and duties of the AAA are prescribed in the agreement of the parties and in these rules and may be carried out through the AAA representative as it may direct. The consumer and the business may agree to change the rules. They can be changed at any time, but y'all have to both agree on there. If they agree to change the rules, they must agree in writing. That goes back to y'all stop calling these people, talking to them, because corporations cannot speak, okay? Everything needs to be done in writing. If the consumer and the business want to change the rules after the appointment of the arbitrator, any changes may only be made with the approval of the arbitrator, period. So when the car company try to change the rules based off of what something different than what that contract says, once you start arbitration, they're only going to get the permission by doing it by the arbitrator. This is why it's important to make sure that you ask for all the documentary evidence, including the purchase order, including the bill of sale. You want all of that because that's going to show something different than the contract that you have. For you guys that got more than one contract, your signature may look funny on one. All of this is going to now help you to go collect the bag 2 times the amount of the contract. So if they said the car was $37,140, you times that by 2. And everything else you need to add in, all your payments back. Stress, I don't care. I had to work 5 extra hours at work so I can pay this car note. Add it all in and make them pay because they're going to settle with you if you write the right stuff on that paper. And it better not be I'm a consumer and I ain't supposed to pay no bills because it's not going to win. Okay, it's not going to work. I'm telling y'all now, it ain't gonna work. Okay, the AAA administer consumer disputes that meet the due process standards contained in the Consumer Due Process Protocol and the Consumer Arbitration Rules. So as y'all see, there's 2 different standards that they are using. They are using the Consumer Due Process Protocol and the Consumer Arbitration Rules. So if I was y'all, I would know them both. Okay, the Consumer Due Process Protocol, the entire book has 452 pages. I read all of them a couple times, you know, that hard work that I do with my ordinary self. Yeah, you know, I read that stuff. So the AAA has the initial authority to apply or not to apply the consumer arbitration rules. So one thing for sure and two for certain, you want your arbitration request to be denied, don't upload that arbitration agreement. You don't have to say too much in the beginning. So you're taking them to arbitration due to violations under the law and your contract. You can say that. You can say securities fraud. If you say securities fraud, you better know how to process that security fraud too, like every level of it, because the goal is to get them to settle with you. Arbitration, the longest time it would take in me to complete an arbitration case was 87 days. The least amount was 19 days. So it just depends on the company. It depends on how much back and forth that we have to go through, but arbitration can be done within 90 days. With it. So, because everybody has deadlines that they have to meet. So once you do the arbitration paperwork, they give them 10 days to respond. Like everything is on the timeline, and do not miss any of your time frames. Like you have to be Johnny on the spot with it. You know, check your promotional emails, your spam email, make a one email just for that so you won't miss it. Because if you miss the deadline, they're going to throw it out. If it's thrown out, you cannot bring it back. They're going to say that it's a frivolous filing and they will not accept it. Okay. So within 30 days of the commencement of the administration, a party seeks judicial intervention with respect to a pending arbitration and provides the AAA with documentation that you're going to intervene. So what that means is, say you decide that you don't want to do arbitration and you want to be big dog and take them to federal court. You have to, within 30 days of them appointing this administrator, you have to let them know, I'm moving it to federal court. If you decide that's what you want to do, I'm gonna tell you right now, federal court and state court gonna throw it out because the other party gonna say there's an arbitration agreement in it. And now you done lost that way too. Okay. Okay. So where no disclosed claims or counterclaims exceed $25,000, the dispute shall be resolved by the submission of documents only. That's arbitration CR 29 on the procedures of resolution disputes through document submission below. Now, most of us on here, if you're doing an arbitration, it's going to exceed $25,000. Not unless you got a car for $5,000. So that's 10. So if it exceeds the $25,000, remember I said there's a part on there that you can submit your documents. That means you're going to have to submit everything. This is now where you can let the left hand know what the right hand is doing. Okay. Once that is done, the arbitrator, they look at both sides of the information. They look at what you have sent and then the response that the company has sent, and then they make a decision there. Sometimes they will need you to do like a live all together one, but if your paperwork is what it is, then they just gonna go ahead and rule. That's why I said one of them took 87 days, one of them took 19 days. The one that took 19 days, all I did was submitted a whole bunch of stuff under this part right here. And they like, yeah, no. No, it was like a 17-page document where everything that they did, every company they sold it to, I was able to get all the documentary evidence that I needed, and it all pointed back to fraud on their behalf. Okay. So the party who starts the arbitration, referred to as the claimant throughout the arbitration, must contact in writing the party that the case is filed against, that it wishes to arbitrate a dispute. The written contract is referred to as a demand for arbitration. Okay, so when you guys do the demand for arbitration, the demand must contain the following. It didn't say and or the following, which means all of it. You have to briefly, and I mean briefly, explain the dispute. We went over that. Securities fraud, violations of the contract due to contract law, due to consumer law, due to TILA. Those are all the different things that you can put. And I will leave it blank. I will leave it just like that real quick. Violation of the contract, violation of the TILA, violation of the consumer laws, Violation of the banking laws. That's all you got to say. You don't have to go into all the details yet. You just want to get the case started. Because what happens is, as soon as this arbitration case just start, guess what they cannot do? Do not pay, do not collect status. They cannot take $1 from you. They cannot repo you. They can't even freaking call your phone. Everything has to be done through arbitration. Okay. So you're going to briefly explain the dispute. You're going to list the names and the addresses of the consumer and the business, and if known, the name of any representatives of the consumer and the business. That right there is where I will list. Like I said, if you got it from RD LLC, they transferred to RD LLC Trust. That is when you will list all of the names and the addresses that hopefully you'll get off of the securityexchange.gov, so you'll have the correct addresses. Specify the amount of money in the dispute, if applicable. So we all know that you go on time 2 times the amount, and whatever else fees that you feel is due to you under the law. Don't be going with no crazy 100 million trial prices. Like, don't do that, y'all. How y'all can get real extra. Like, don't get extra, because then they're gonna be looking at you crazy. Okay. Nephew, can you finish that page? I need to go get my charger. If not, the hose don't bite.
No, I got you. Where were we at here? Specify the amount of money in the dispute. Identify the requested location for a hearing if an in-person hearing is requested, which no, you don't want to do that. You're really just looking for a Zoom, but also state what the claimant wants. So this is where, at least what it seemed like, is you're gonna list your demands. Because you got to tell them what you want, and then they are most likely, the claimant must also send one copy of the demand to the AAA at the time the demand is sent to the respondent. When sending a demand to the AAA, the claimant must also send the following: a copy of the arbitration agreement containing the contract and or purchase document, the proper filing fee. The amount of the filing fee can be found in the costs of an arbitration section of this rule. And if the arbitration, this is on the next page, you can't see it. If the arbitration is pursuant to a court order, the claimant must send one copy of the demand to the AAA at the same time the demand is sent to the respondent. When a demand sent to the AAA, the claimant must also send a copy of the court order, a copy of the arbitration agreement, and the proper filing fee. The filing fee must be paid before a matter is considered properly filed. If the court order directs that a specific party is responsible for the filing fee, it is the responsibility of the filing party to make such payment to the AAA and seek reimbursement as directed in the court order to make such other demand. So, and then it goes on to tell you that you can file by mail and where to send it. But basically, when you're sending your demands, you got to send it not only to AAA, you have to send it to the respondent. And then if it's through a court order, you would have to send it, send a copy of the court order, and you also have to send the filing fee, right? So in your, claim for what you want, you can include that you want that filing fee back, because again, they're supposed to pay it up to $5,000 in the event that you win.
Absolutely correct. And the thing is, thank you, nephew. When you go under the AAA, you send over that portion that says there's an arbitration agreement in there. If it says, like the last contract, that the company is responsible for the payment, you don't have to pay anything. They will automatically send that to them and make them pay. One thing I like about the AAA, they will send your complaint over to the company, but we also have to follow the rules. They also say that you have to send it as well, okay? And we also know that anything with your signature is considered a security, so you're going to send it properly, and it will be addressed to the law department or the legal department, okay? It will say legal department and not law department, because there is no law. There's only legal rules and regulations, okay? Here's the address, as you see, if you're going to do mailing. But you can also file online, which I will show you guys how to be able to file this case online. It is best to do it online. That way you know that they got it, okay? Or you can file at one of the AAA offices as well. Hey, where'd that go? Okay. So y'all know what to add. Once again, briefly explain the dispute, leave it short, leave it simple. Don't be trying to act like, you regurgitating everybody else's words. Leave it short, but make sure that those short words are powerful. Using words like securities or certificate of indebtedness or things, whatever is, whatever it is that is pertaining to your particular contract, okay? And make sure that when y'all do these fees, please stay within the law. Whatever your law says that you can sue them for. We know under TILA is 2 times the amount of the finance charge, and that's not the interest rate. That, once again, is the full amount of the contract, okay? And you can file online. If no answer is filed within 14 days, the AAA will assume that the respondent does not agree with the claim filed by the claimant. The case will move forward after 14 days, regardless whether an answer is filed. So if they don't respond, it's going to go on. But that also applies to you. When I told you there are timelines that you have to meet. No ifs, ands, or no buts about it. If you don't make those timelines, it's not going to look good in your favor. Okay. When sending a demand or an answer, the consumer and the business are encouraged to provide enough details to make sure that the dispute is clear to the arbitrator. So you're going to make sure that it's enough details in the beginning so that the arbitrator understands the type of case that it is, but you don't want to still give them too much until you get closer to the end, after you got the companies, they gave them the contract, the right contract, and things like that, okay? Now, for those contracts that do not have an arbitration agreement in there, you guys can still do arbitration, but both parties have to agree to it, okay? So if it's not there, you can still do arbitration. What will be your basis to arbitrate a case that don't have an arbitration clause? The basis will be Title 12, that all securities are federal cases. That's it. That's all. No more. Okay. If you decide to do that with a contract that doesn't have an arbitration clause, it must be in writing. It must be signed by both parties. You got to briefly explain the dispute, list the name and the address of the consumer and the business. The amount is done the same way. The only difference is you're going to have to get that company that you are suing to go to arbitration with you. Now, a surefire way to get a company on a contract to arbitrate with you is to act like a snitch and tell them you're going to snitch and say, you either go arbitrate with me or I'm contacting the security exchange for securities fraud and a violation of your security agreement. That's it. That's all. Okay. I'll say it again. If you do not have an arbitration agreement, which like most buy here, pay here lots have, or any other, most contracts have them, but the ones that do not, if it's dealing with a security, and we know that it is, the way that you get that company to sign off on that dispute is that you advise them that you're going to report them to the security exchange for securities fraud under their security agreement that they have on file with the SEC. And that you're now going to take them to equity chancery court. I ain't say federal court. I said chancery court, because chancery court is the court of equity. It is located in Delaware. Now, do you understand why most of the companies that you guys have looked up, parent company is in Delaware? Yes, there is a chancery court and you can take them there. And that's how you'll get them to arbitrate with you. Then both of you got to send the submission agreement to the AAA, pay the proper filing fees, and there you go. Okay. Now, if there is no arbitration agreement there, and it does not say that that company will pay the arbitrary fees, at that point, if you don't have an arbitration agreement, or it doesn't say that you're going to do the fees, you will now have to pay that fee according to the fee schedule that can be found at the cost of arbitration. Okay. They are not-for-profit organization, blah, blah, blah. We don't care about none of that. But they do get paid. This is, they do require the company to pay a deposit. So, Once you create your demand letter and it has been filed, any new claims, counterclaims, or changes to the claim or counterclaim must be made in writing and sent to the AAA. So just remember, at the point that you start arbitration, send everything through your portal and through the AAA, okay? And of course, they got 14 days to notify the parties if we receive new or different claim or counterclaim to file an answer statement with the AAA. So once you do it or they send a complaint, they got 14 days. Like, for example, one of the cases I'm working now, they had the audacity, you know, that audacity people like to get. They had that audacity to try to put in a claim to say, throw out the whole arbitration case, because we ain't told them nothing but security fraud. Yeah, and arbitration said, nice try, we not having it, we're going to do it. You know what I'm saying? So they will try you on that. But even with that, we still have to do an answer to them in 14 business days. If not, the case is going to be thrown out. So those timelines are very, very, very important. Okay. So if the claim is within the jurisdiction of small claims court, we all know that you can't take securities to small claims court. So just bypass that. It does make a difference. But even if, let's just say that the company says, oh no, we want to move from arbitration and we want to move it to small claims court, your defense to that is an arbitration clause in there, and all securities are to be held on a federal level, because they will try you there too and try to get you to state court, because state court is gonna rule in their favor. They're gonna say that you owe, and then it's gonna be a wrap. Okay. At the request of any party, or if the AAA should decide, the AAA may have a telephone conference with the parties or their representatives. We already know what representatives you can get. You can get a consultant, you can get a lawyer, you can get a third party to help you fight your case for you. They normally don't do no in-person things, so we don't have to go there. So let's see if there's something else I want to get you guys. They pulled their arbitrators off of the national roster of arbitrators. You can actually pull those names up and you can see what type of person they is. I would, because you can get your arbitrator changed, and you can have a panel of 3 too. So those that's been doing this for a minute know what a panel of 3 and the power of them. And have 3 different people decide the case if that's something that you wanted to do. If you do not appoint your own arbitrator, which you can, okay? If the parties have not appointed an arbitrator and have not agreed to a process for appointing the arbitrator immediately after filing the submission of the agreement or the answer, or after the deadline, there we go with them deadlines again, guys, the AAA will appoint the arbitrator for you from the national roster. I don't know how they pick them. They just take one off of the roster and say, okay, this is who you got. Okay, here we go. With the 3 parties, if the parties' arbitrator agreement provides for 3 or more arbitrators and they have not appointed the arbitrators and have not agreed to process for appointing the arbitrators immediately after filing the submission agreement or the answer, or after the deadline for the filing answer, the AAA will administratively appoint the arbitrators from the national roster. Okay, the AAA will appoint the chairperson on that. If the arbitration agreement does not specify a number of arbitrators and the parties do not agree on the number, the dispute will be heard and decided by one arbitrator. Depending on what company, you might want a panel of 3, depending on what you're doing, depending on how deep you're trying to go. I would definitely have a party of 3 if you're trying to get your credit card open-ended. Do a party of 3. Because you don't know if that arbitrator, because we all know they work for each other. We all know that they ex-judges and things like that, and ex-attorneys, and you know they all rub elbows together. So to make sure that your arbitrator ain't in bed with the person you taking to court, you can ask for 3, a panel of 3 or 2, and you can choose them. The disclosure information would include any bias, any financial interest in the result of the arbitration. That goes back to what I just said. Any personal interest in the result of the arbitration, or any in past or present relationships between the party of the representative. Google and the internet is just everything that you need these days. So I would definitely look up who my arbitration person is. I would definitely look up who my attorney is, because the attorney for the other side, because they have to give their resume. And I would see if there's any correlation, anything. Is you married to his sister, cousin, mama, sister, the neighbor down the street? Did y'all go to school together? You know what I'm saying? Like, you want to do your homework, because we all know that these companies pay these people to rule against us. And don't forget, arbitration rules. Hey, one shot, one chance, that's it. So that's the disqualification of an arbitrator. And we just went over that, which will be considered disqualification. So do your homework. So when it's time to prepare for the hearing, if any party asks for the AAA or the arbitrator decides to hold one, the arbitrator will schedule a preliminary management hearing with the parties and or the representative as soon as possible. The preliminary management hearing will be conducted by phone unless the arbitrator decides an in-person preliminary management hearing is necessary. They normally do not. Okay. During the preliminary management hearing, the parties and the arbitrator should discuss the future conduct of the case, including clarification of issues and claims, scheduling of hearings, and any other preliminary matters. So now, after you upload all of your information to that system that we talked about just a few minutes ago, and the arbitrator looks at it, he can really make a ruling based off of that. If I was you, I will always ask. You see that? If any party asks for, or if the arbitrator decides to hold one, you don't want them making a decision on your case and you've never been heard, or your consultant has never been heard. So you're going to always ask for that preliminary management hearing, so you can get on the line with everybody, so everybody can see everybody, and it can get an understanding that if y'all don't do what I say, I'm contacting the security exchange, point blank period. That's going to always be your A's and O's. You know, it's okay to be a snitch when it comes to the corporation. Just don't snitch on people, okay? We don't snitch on people. The exchange of information between the parties. If any party asks, or if the arbitrator decides on his or her own, keeping in mind that the arbitration must remain a fast and economical process. So that's why I say it could take up to 90 days. It normally don't. The arbitrator may direct particular documents and other information to be shared between the consumer and the business. So now, remember when I said that you guys can now ask for all that wonderful documentation that you want, that they've been ignoring that affidavit that you've been sending them? This is the time to ask for it, because they have to, the arbitrator is going to ask on your behalf, okay? That's how you get that the consumer, and you can also have witnesses, if any, that plan on testifying at the hearing. Yes, you can have witnesses testify on your behalf if they have firsthand knowledge of what's going on. Okay. Any exhibits the parties plan to submit at the hearing need to be shared between the parties at least 5 days before the hearing, unless the arbitrator sets a different exchange date. So they normally do have a set timeline, but this is where you make sure that all your exhibits, so say you tried to settle this with the company before by doing an affidavit, by doing an administrative process, have all of those documents, because you want to share that. You want to show that you've done your due diligence to try to settle this with them before you came to arbitration, okay? The arbitrary administrators, they like that. Take them from me, because they see that you just didn't run the arbitration, like you really tried to settle this with them. They didn't want to help, or they ignored you, and now you're coming to them for help. They do like that, so make sure you have it so that you can upload to your portal, okay? Written motions. The arbitrator may consider a party's request to file a written motion only after the parties and the arbitrators conduct a conference call to assent to resolve the issue. So yes, you can do different motions. Only after the parties and the arbitrator hold the call may the arbitrator consider a party's request to file a written motion. The arbitrator has the sole discretion to allow, deny the filing of a written motion, and his or her decision is final. This is why I always say, depending on the company, you want to have more than one arbitrator, because like I said, what if they end up being with each other, okay? You don't want them to say, no, you can't put in your written motion because they didn't get paid off by audit or whatever, not to do it. So it's always best to have more than one person there, and it's always good to have a witness on the line. You are allowed to have a witness on the line with you that can contest if anything in this hearing goes not as planned, okay? Any party may participate in the arbitration without representation or may be represented by counsel or other authorized representative. So that's when you can get you a consultant or someone as an authorized representative via POA for him to be able to speak on your behalf, unless such choice is prohibited by applicable law. It's not. You can always have it because that is a part of the federal arbitration rules, that you can have someone that is not an attorney, which also falls in line with 15 U.S.C. 6092 E7, where it says there are no attorneys. Okay. A party intended to be represented shall give the opposing party and the AAA the name, address, and the contact information of the representative at least 3 days before the hearing, where the representative will first appear in the case. So if you hire someone to assist you, you have to make sure that you provide that person's name, their address, and their contact information 3 days before the hearing, not 5 minutes before, 10 days before. It has to be 3 days, at least 3 days before the hearing. It will be considered proper notice if a representative files the arbitration demand or answers a response for a party during the course of arbitration. So what that means is, say let's say Dare put in an arbitration agreement, an arbitration case 2 months ago, and he not coming to me like, I need your help. I can go in now and send an email for him. I can go speak for him, and he can sit there like he's doing right now, watching me tear their ass up. Okay, with a smile on his face. So that can be done that way. Okay. Here we go. While parties do not need an attorney to participate in arbitration, arbitration is final, legally binding process that may impact the party's rights. As such, party may want to consider a consulting attorney. We know ain't no damn attorney, so they just want to put that out there. But that is true. Don't go into arbitration blind. Don't go into arbitration without being armed, because it's a legally binding process. Your only recourse will be a complaint with a security exchange. But now y'all got to remember too, the security exchange is a part of the fraud. They know what's going on. You know, they do something when you do a whistleblower for them, but until then, they're going to keep getting their pockets lined up by keeping everything away from the consumer. Okay. Setting the date, time, and place. It's normally over the phone, as I said. A hearing may be by telephone or in person. Please respond properly to the arbitrator when he asks about dates. The parties available to the hearing, they do give you, they'll give you 2 or 3 dates and say, are these dates good for you, for everybody to agree? Don't be like, oh, I forgot, or I missed the call, or how y'all good to say, I ain't got the email. And the email is right there. You know, make sure that don't happen, because you're going to lose. Okay, you're going to lose, and I'm telling you now. They will send notice of the hearing at least 10 days before the hearing date, unless you guys agree upon a different time frame, okay? If a party wants a written record of the hearing, the party must make such agreement directly with a stenographer, court reporter, and notify the opposing parties. Now, let me tell y'all something. Arbitration hearings, which is why you guys don't hear about so much remedy that people are getting, is only found through discovery. But you know, discovery is easily found when you hire your own stenographer, okay? When I'm fighting big cases for people in court, you know what I tell them to take? A notary and their own stenographer. You have a case and your stenographer set up that damn thing and get the type, and watch how fast they get you up out of there, because ain't none of them on the record. And the stenographer is not expensive to have. So yes, you do. I have stenographers on all my arbitration calls, because I don't want nothing misconstrued, or them to lie and say they ain't say this or they didn't do this. Yes. Okay, but you do have to let them know at least 3 days before the hearing. You can't just pop up on the day of the call talking like, I got Sally Sue here and she about to get the type it. They're gonna be like, no, Sally Sue got to go. Okay. No other recording will be allowed unless the parties agree or the arbitrator directs a different form of recording. So you cannot record it. You can't have nobody else record it, because if they find out you do, you're in violation of a federal law, and now they're going to charge you federally. This is why I say you guys never see about arbitration cases, because it cannot be recorded. But you want to have the documentation, right? So how y'all going to get the documentation? By hiring the what? A stenographer. So you got to spend a little money sometimes, but you got to hire one. Ain't none of that pre-record. Now I'm trying to put it on Facebook because they're coming for you. Period. Okay. The arbitrator may resolve disputes between the parties over who will pay the cost of the written record or the type of recording. So now, me personally, I front the cost for my clients to get the stenographer there. And then when it's time for us to get paid, I need all that back. And they do give it all back. Okay. The parties can agree or the arbitrator may decide that the transcript is the official record of the hearing. If it is the official record of the hearing, the transcript must be given to the arbitrator and made available to all the parties so it can be reviewed. The date, time, and the place of the inspection will be decided by the arbitrator. Okay. If you need an interpreter, they're there. If English is your first language, get one. So here we go again with the documents only procedure part. Disputes may be resolved by submission of documents and without in-person or telephonic hearings. For cases being decided by the submission of documents only, you will upload those documents for under the procedures of the resolution of disputes through document submission. So that's basically you and them doing it off the record, even though it's going to be on the record, hearing, trying to mediate between each other so that it will not go all the way through arbitration. These procedures would apply where no disclosed claims or counterclaims exceed $25,000 unless any party requests a in-person telephonic hearing. So we all know that it's going to exceed $25,000. Okay, not unless you're suing like one of the credit bureau agencies or something like that. So because it's going to be over $25,000, that is an automatic, meaning that you upload your documents and you cross your fingers and you hope that they do your way. No, request the hearing. Always request the hearing, guys. Don't let them decide for you, because I told you they can, they could have just came out the bathroom with each other and you hit. Here is the procedures for the hearing. They will keep you the information about the arbitration private. So y'all want to know why you don't never see it. It tells you there. It's private. But we all know that there is a public living and there's a private living. Right? So arbitration is private because we're dealing with securities and securities is private, the way that they're doing it, okay? Oaths before starting the hearing. Each arbitrator may take an oath of office, and if required by law, shall do so. If the arbitrator determines that the witnesses shall testify under oath, then the arbitrator will direct the oath to be given by a duly qualified person. Me personally, I asked the arbitrators for their oath. I want a copy of it, because are you even supposed to even be doing this? So now let me see a copy of your oath. Yes, you can ask them for a copy of their oath of office. You can present your evidence to support your claim. The respondent must then present evidence to support the defense. Witnesses for each party also must answer questions from the arbitrator and the opposing party. The arbitrator may change this procedure as long as the party has the right to be heard and is given a fair opportunity to present his case. You're going to get that fair opportunity to do your case because you are going to request a telephone hearing. This is how you know for a fact you are being heard. You're going to have your stenographer there, because if they don't do what you want, then you're coming back. But now you're coming back a different type of way. Normally you don't have to, but just have all your ducks in a row, okay? They move a little different when they know they got a stenographer there and you can ask for oaths and things like that, okay? So yes, you are able to give your evidence of the claim, and no, it is not all my bills supposed to be paid by the United States. Okay, that's not evidence. What's evidence is when I broke down that contract last week and I showed y'all all the fraud that y'all never realized was in your contract because you never read it. Guess what? That's your evidence. Printing off the way that they transferred your securities under SBG Global, that's evidence that you can use against them. Right? Showing that under TILA, everything was supposed to be added. That's evidence against them. So that is the type of stuff that you want to have to support your claim if you want to win. You can present evidence in all type of ways: web conferencing and internet communication and telephone conferencing. So remember I said that they may try to email you on a slide, use that all as evidence that they're trying to play you to left, okay? All procedures must provide the parties with a full and equal opportunity to present any evidence that the arbitrator decides is material and relevant to deciding the dispute. Don't go in there talking nothing that don't have nothing to do with your case, okay? Because they're going to throw it out and you're going to look crazy. The arbitrator will use his or her discretion to resolve the dispute as quickly as possible and may direct the parties to present the evidence in a certain order, or may split the proceeding into multiple parts and direct the parties in the presentation of evidence. The hearing generally does not exceed 1 day. So when I say you got one shot, you better make it. Okay, don't act like Shaq at the free throw line, okay? Please don't act like Kobe, okay? Don't act like Shaq at the free throw line because you're going to be hit. You got one. This is a one chance, one time only, okay? Now, you can waive oral hearings. Don't waive it. I don't care what you say. Do not waive it. With it not exceeding 1 day, if one party shows good cause, they can schedule additional hearings within 7 calendar days of the first hearing. So y'all see how fast it go. The most time that it takes during this is the sending of the paperwork. That's why I say it can take up to 90 days, which it normally don't, because you see all the timelines they give them. When you first do it, they got 14 days to respond. Then they do it again, they got another 14. Every time something is given, they're given 14 days, right? But if your shit is concrete, I'm trying to tell you, if it's concrete, you done broke that contract down, you done put it against TILA and everything else, they're going to be like, hey, come on, let's talk about this. You know what I'm saying? Sign this little NDA for me though real quick, but then we're going to pay you, right? And then the good thing in there, you can tell them how fast to pay you. In all my hearings, they got 72 hours to pay my people. They need it with 72 hours. And to me, the law says business days is Saturday and Sunday too. So if they operate on, got anything open, the bank, the ATM work, okay, Saturday and Sunday is the business day. So this is when you get all that good stuff. Y'all know how y'all like to demand a lot of stuff out of me. Let me see y'all demand these people to pay up. Because this is when you're going to get it, okay? Let's see. The evidence, we already went over that. For the most part, the evidence is break y'all contract down, guys. When y'all get the recording from last week and this one put together, I broke that contract down for you guys. Break it down, have it written down, and make sure that you are prepared. I don't care if you got to talk yourself into a mic and then redo it. You know what I'm saying? And play it all night while you sleep, whatever it takes, or hire you somebody that know what they're doing, because this a one-shot chance. A arbitrator or other person authorized by law they can subpoena witnesses or documents. So y'all know them certain documents. Let's just say you ask them for all of the documentary evidence, that you asked them for the allonge that was supposed to go with that title every time that they that security, every time they transfer it to a new person. That's when you can get to asking for all that, so you can see who actually has been profiting off of your thing. If they refuse to give it, make the arbitrator subpoena it. If you decide to use witnesses as evidence, you're going to have to do it based off a declaration or an affidavit. I did not say affidavit of truth. Do not put the word of truth behind that, because that's not going to mean anything, because the affidavit of truth is only your political and religious status preference only. That's why they go unrebutted. That's why they don't never say nothing, because they can't tell you what your status is, okay? So if you're going to have evidence and witnesses, either do a declaration or an affidavit by testimony. So the arbitration administrative officers, they haven't been bad. So let's go down to the part that y'all want to talk about. So let's say you didn't get your way, but you want to come back. You can request for it to be reopened before the award is made. If reopening the hearing will prevent the making of award within the time agreed by the parties in the contract out of controversy has risen, the matter may not be reopened. So let's just say you decided to go with an agreement and you're going to take $2,000, but then you wake up and realize you could have got $20,000, but they already agreed on it. You hit. You're going to get that $2,000 and just, walk away with it. So make sure that you take into consideration everything, because even when they do the award, you got time to say, okay, yay, counter it, or I'm going to accept it, okay? The award shall be issued promptly by the arbitrator. unless the party agree differently or the law indicates a different time frame, no later than 30 calendar days from the date the hearing is closed. If the case is a documents only procedure, like I showed y'all earlier, no hearing, you just uploaded your paper and crossed your fingers that you did it right because you ain't used somebody else's template because you are the template. You know what I'm saying? You, the template, you created it right. If it's documents only, it's 14 calendar days from the date that the arbitrator set for his or her receipt of the final statements and proof. So then they have to pay out within 14 days. Okay. The award will come in writing and executed in the form and manner required by law. The award should provide the concise written reasons for the decision unless the parties all agree otherwise. Any disagreement over the form of the award should be decided by the arbitrator. You want them to make sure that they put down in writing to help out your next brother or sister who may have the same company and they can get this through discovery, why it is that that award was given. Okay. The AAA may choose to publish an award rendered under the rules. However, the names of the parties and the witnesses will be removed from rewards that are published unless the party agrees in writing to have his name included in their reward. So now when you want to be big dog and you want to brag all over the internet that you beat this company, make sure that you get it. You give them permission to publish it and tell them to put your name if you want your name. Okay. The arbitrator may grant any remedy, relief, or outcome that the parties could have received in court, including awards for attorney fees and costs. So what that means is, Tila say you get what? 2 times the amount? That is what you would have got in court. Okay. Then you can add in your attorney fees and costs. Don't get in there talking about no pain and suffering. No, none of that. Okay, don't do that. Just take the money. You got enough people to arbitrate with to collect a whole lot of bags and be straight for a minute. So be reasonable with your amounts. So, award upon settlement. If the parties settle the dispute at any point during the arbitration and at the party's request, the arbitrator may lay out the terms of the settlement and the consent award. So that means when you guys go through that part and they tell you to try to mediate, if you guys come up with a settlement, guess what? You still got to go through the arbitrator because he still have to draft it up because you started this arbitration hearing. You can't just walk away from it. Okay, the consent reward must include a division of the arbitration costs, administrative fees, expenses, as well as the arbitrator fees and expenses. So you guys make sure when you're asking for your money, if you hire somebody, put that back in there. The fees that the arbitrator charge, any of the fees that are associated with the arbitration case, make the other party pay for it, okay? Consent awards will not be available to the public. Let me highlight, make this bigger, because y'all love to run on social media. I see what they say. It will not be made against to the government, to the public, I'm sorry. So y'all want to know why y'all never see them? Why I never post them? Y'all know I post every receipt. It's because the award amount cannot be made to the government. I mean, to the public. I don't know why I'm talking about the government tonight. Made to the public, okay? Unless you guys agree otherwise. And I can promise you, on everything I love, which is my kids, you can say, oh, I want it to be shown that I'm big dog and I got 200 trillion freaking dollars from Audie or whatever. And Audie gonna say no, and y'all both have to agree. This is why y'all never see them again. The delivery awards to the parties. Parties should accept, as notice and delivery of the reward, the placing of the award or a true copy in the mail addressed to the parties or their representative at the last known address, personal or electronic service of the award, or the filing of the reward in other manner that is permitted by law. So they can send it in the mail, electronic service, that sounds like a EFT, a ACH, send it to my bank account. Okay, you don't want it to be mailed because they're gonna lie. Go ahead and say, you know, draft it and to put it in my account the same way y'all was drafting it out my account very quickly and expeditiously, okay? You got 20 days after the reward is done. If there was any mistakes on your paperwork, a name spelled wrong, something was left out, or whatever the case may be, you got 20 days to get them to fix any clerical or mathematical errors, not for them to go back and redetermine the merits of the claim. It's already been decided. As I said, it's a one-stop shop, home run. There it is. The opposing party shall be given 10 days to respond to that request. The arbitrator shall make the decision on the request within 20 days. You make your time longer, just make sure all your paperwork is right, okay? Because you don't want to have to go back. So post-hearing, the release of the documents, the AAA should give a party certified copies. For y'all who've done court cases with me, I tell y'all how important those certified copies are, because now certified copy makes it a true bill. Okay, they're saying that the facts are on there is true. And if somebody put their seal and their signature verifying that. Okay, so the AAA should give a party certified copies of any records in the AAA's possession that may be required in judicial proceedings related to the arbitration, except for the rewards determined by the AAA to be privileged or confidential. You will have to pay a fee for that service if you want the certified copies of it. And once again, you see privilege and confidential, which means enjoy your money in peace and don't tell the world. And no court or judicial proceeding by a party related to the subject matter of the arbitration shall be deemed a waiver of the party's right to arbitrate. So what that means is, if you are being sued right now by a debt collector and they got you in state court, that does not waive your right to arbitrate. What it will do is remove it from state court so you can flat out arbitrate, okay? Parties to any arbitration under the rules shall be deemed to have consented that judgment upon the arbitration award may be entered unto any federal or state court having jurisdiction thereof. So we know it ain't gonna go to state court, they ain't got no jurisdiction. Can a copy of this be found in federal? It could, but you have to find it under discovery. Outside to ask for additional time. That's about it. You guys can find this on adr.org. If I was you, I would go through it all of the way. Once again, the timing of the award within 14 days from the date the hearing is closed, you will get paid. Point blank and period. You could tell them to direct deposit into your account if that's what you want. You can tell them to send in the mail, send it by telegram, send it by dog. But you can tell them how it is that you need your stuff sent. Okay, so that's that. Now let's get to so the first step in doing arbitration, you have to do a demand for arbitration consumer arbitration rules. This is the form that you will use. It is on their website. Under the American Arbitration Association, you will find this form. Okay, so if you are the consumer, you're gonna check consumer. As y'all see, you can type on this form. Okay, so it'll be, you can put violations of TILA, consumer laws. You can put securities fraud. It said be brief, right? Under Title 12. You ain't even got to put the Title 12, but just be brief. So the sum of money that you're going to be asking is going to always be 2 times the amount of the finance charge, plus all consulting / attorney fees. Now that way you make sure you get all your money back, okay? State any other relief you are seeking. It also says it here again, so you can put arbitration costs. You really don't have to put it up here because they did that. I always do, but let me not make it hard for y'all because I'm like, what did you say? So I ain't got time for it. So you can put arbitration costs. If you got an attorney fees, you can put attorney. Well, if you don't have an attorney and you're using a consultant or something, you could put consulting fees here. Interest. Make sure y'all always check interest. Check the interest. box because you want the interests of the security in which it is that they are transferring, and what you asking for interest, because they're going to ask you what are you asking interest on? That is how you get them to cough up that damn paperwork showing that your security's been transferred. Okay. Identify the requested city and state of the hearing if an in-person hearing is held. If they normally don't do in-person hearings, as I stated, but if they do, put your city and state that you live in. Okay, then the consumer information. This is your information. Your address. Just all your information. If you have a representative that will be assisting you in this process and you have it from the beginning. Oh, that sucks. Hold on, y'all. Okay. If you have someone that is going to be assisting you, you will put their information here. Okay. The business info, whatever business that you're going after, you're going to put their information there. As I said, it is best to pull their information off of their security exchange forms. Okay. If they have any business representative, this is what you'll put. Hey, you know, on them 10K, 8K forms, and they tell you who the indentured trustee and the trustee is, and they have an actual representative. Yeah, their name will go there. So once you fill this out, this is all you need to get started. This is all you need to get started, guys. And guess what? At the point that you did it and they accept it, your bill just went in do not pay, do not collect status. I told y'all I was going to show y'all how to stop immediately paying these bills and get your remedy, because that's what everybody's problem is. They can't pay their bills. Well, not can't. They don't want to pay their bills because they're not supposed to, right? So this is how you get that do not pay, do not collect status, but don't have to worry about while you sitting there, the lights go zip up or the gas went, or you went outside trying to go to the grocery store and your car got gone, okay? None of that will happen once you do this portion here. So it says send a copy of the completed form to the AAA together with what they say, a clear and copy of the contract. So you have to upload the contract to say that you guys will agree to arbitrate the disputes. So that portion of your contract, please upload it. You have to upload it, okay? And the filing fee. But of course, if it says in there that the company, which they normally do, is responsible for the fees, then they will contact them about the fees, okay? So don't, they send me an email to me, I gotta pay. No, they did not. It's not for you to pay. What you have to understand is any document that the arbitration representative sends to the other opposing side, you're gonna automatically get a copy of it. And they do everything via email. So make sure your email work. It may go to spam. We know how y'all get it. I ain't got it. Yeah, you do. Just go look for it, okay? You can also send it by mail. I do not advise that. Just go ahead and file online under adr.org and click file or access your case, which you will see is right here. Okay, I'm under adr.org, guys. Go right there, file or access your case. And then this is where fast file. Quickly file a case online with AAA using the contract and a demand form with guest access. There you go. If I was you, I will get an account. I think it's free. I got an account with them for something totally different, and it's like $2,000 for the year. So y'all don't need that one. For people who have more than one company, to file at least 25 cases, if it's workplace or something, you can do that. To file at least 25 cases where the consumer arbitration fee schedule applies, then this is where you'll go here. So you filing for no fault insurance. I told you y'all can file arbitration for everything. It's right here. And this is how you manage your case. Okay, so you will create you'll create an account. So when you need to know what's going on, you can sign in and access and manage your case from this page. So when you first start, I'm gonna go right to the top. First, I will register if I was y'all, so that you can just log right back in and file your case this way. And so it's called fast file. So if you in repo status right now, if I was you, I would get to filing. If you know you ain't paid that car note in 90 days and they coming, please go online and file ASAP so they cannot take your shit. Okay. And this is simply the form. Look at that. It's very simple. And this is the fast form. This is just to get it started. They will ask for the rest of the information as it get closer and closer and things get to rolling. But hear me and hear me good. If you in repo status or they about to cut my credit card off or whatever the case may be, I would do a fast file immediately. Okay, and you see the same thing. Upload the filing form, upload a copy of the arbitration or the mediation agreement, pay the fee. Y'all know y'all don't have to pay the fee as long as it said it. Put your name, your email. Are you filing for arbitration or mediation? You know that it is arbitration. You're not doing mediation. They're going to offer you mediation in the arbitration process. So make sure you put arbitration there. If you got any special notes, which you probably will not, you have to enter NA, which means you cannot leave this box blank and you try to move on. It's not going to work. Okay. So, because y'all like to skip words. So if there are no special notes, please put capital A/A, not applicable. Okay. The documents that you have to upload, as you see, what I say right there, attach. You can attach up to 10 files. Okay. Please read before submitting. Make sure that you have uploaded the filing document. So the filing document is this one. Sorry. It's this one. This is the filing document that they're asking for. Okay. So you'll fill that out. You will upload that. And then you will upload a copy of the case. A copy of your contract that says arbitration. That's the only thing you're going to start with. That's it. That's all you need to get this started. Okay. And if you got a repo, like I said, please stop. Just to stop it, like immediately, but you better hurry up. I would still have my car about y'all until you got the paper back saying that they went on there and started it if you're in repo status. And I'm not being funny. I'm being straight up serious because y'all know how they get when you get to assert your rights. One thing about asserting your rights this way, when you do it through arbitration, they not gonna try no fuckery with you. Okay, they not gonna try no, oh, you sent the affidavit, so now we're gonna come repo. They're not gonna do any of that because they know that arbitration is now looking. Okay. So that is the form that you'll need to get it started. Nephew, you got anything you want to say?
Nope. I don't got nothing else really to add. Just again, besides the fact of knowing all the reasons why and why you're going at them, because when they start asking for the reasons and they start asking for the proof, it's going to be on you to understand completely why you're going at them.
Yeah. And we showed y'all last week how to break down your contract, use it with the corresponding laws, and win your case. If you don't feel like you can do it, we're here to assist. That's all I can say. Do not play with arbitration. Don't just do it because you watch one video. I would definitely pull up the arbitration rules. I will go over this website. I will go over the documentation, and make sure that you are prepared to battle some attorneys. Like I said, if it's done right, you're gonna win all of your remedy. And I ain't never told y'all a lie yet. You want your open-ended credit card arbitration. Arbitration. You want the title to your car, plus all your money back, plus the full value of that contract times 2. Arbitration. You want to get the credit agencies for using your information and violating the Privacy Act of 1974 and the Family Educational Act and every other act in which it is that they have violated, take them to arbitration. You want that $1,000 per inquiry that they put on there, take them to arbitration. And remember that the arbitration outlives the contract, which means the contract can be old, the car can be paid for, the whole 9 yards. You can go back and get your money. Okay, just understand you pull UCC 9 as it showed you when we were going through the document. because these are the things they're looking for. And you have to remember that arbitration is equity and law. Now you can use the law. And USCs are not laws, they're codes. So that means you want to know the UCCs, state and federal level. You want to know contract law. You want to know TILA and everything that's supposed to go with TILA in order for you to do this. If you can't do it, find somebody to do it for you. But will you definitely win? Absolutely, you will, if it's done correctly. I'm very proud of myself on 20 and now, my ordinary self. So, yeah, that is how you do it. Hey, Kimberly, that's my girl right there, honey. So that is how you do arbitration. Y'all pull those arbitration contracts. Do one at a time. Don't go trying to do 50. But also for real, if you are having an issue and you may be possibly losing your vehicle, do that arbitration so that you can stop them. This is how you get all of your bills and do not pay, do not collect status without the adverse actions coming behind you. Everything else, y'all be saying, they adverse action, watch this. They're not doing no adverse actions with you with this, because now the federal jurisdiction, which is the correct jurisdiction according to Title 12, with securities, they are looking at them. They're not gonna make no dumb moves with you. But make sure you don't make no dumb moves with them by going in blind or not understanding why you're doing it. So break your contracts down, write it down, put the corresponding laws that goes with those contracts. Y'all see how easy it is to start an arbitration case, and they respond very quickly. Butterfly can tell y'all that. Where's she at? Butterfly, you in here, raise your hand. I don't see her. I don't know if she's in here tonight. But yeah, like with her case, I can talk about it now because we're not done, but they just tried to send a paper and talk about dismiss her claim. Arbitration said, yeah, not today, baby, or tomorrow either. You know what I'm saying? Talk about she didn't say enough. She ain't have to say a lot right there. Like I said, you don't let the left hand know what the right hand doing. Like nephew told you, they will come up with something. Do not send them the contract. I'm telling y'all every trick they're going to try. If that email, after you've sent it to arbitration, if that email do not say that it came from arbitration, don't listen to them, just tuck it away. So when you get to supporting evidence, then they on, because they'll try to do something like a settlement hearing with you. Don't do it. Don't do it. Make sure that everything goes through the administrator of the arbitration within 5 days or less of you putting in the initial hearing paperwork. You will hear back from them. Once you hear back from them, you know that your item, well, whatever company you went through is safe. And if any correspondence is done off the record, if you respond to them, make sure you tag the arbitrator and put it through the portal and let the arbitrator send all the information to them. They answer you a little bit differently and a little bit quicker if you do it that way. Okay. Arbitration is very important. And arbitration is your true way to get remedy where you don't have to call them every single month, sending them a letter, trying to do, or they just did it for this month and not the next. It don't work that way. And make sure that when you do arbitration, you ask for everything under the law, because they're only going to give you what the law says. So you know for a fact 2 times the amount. And that's one of the main reasons that you want to get a copy of the purchase order, because at the very end of the purchase order, when they add up all them numbers that they give you, it says a negative number at the bottom and it says finance charge. So that lets you know that the full amount of the contract was the finance charge. How can you make sure that they know that? Make sure that you order that agreement through the arbitrator to them, because TILA said you can. Right? The law says you can ask for documentary evidence. The law says you can ask for accounting under GAAP. Take a time out to use that word. You might want to go to general accounting practices. You might want to go look that up, because those are all the wonderful things that you can ask for. And if I was you, you really want them to settle with you real quick. Tell them that you need the GAAP accounting according to GAAP. And everybody that is holding that contract right now, you need to know about it. That what happened to the allonge page, ALLONGE, the allonge page. this lien or security interest that they say that they have, tell them to prove it. Because only the original creditor or the original, the original creditor can put a lien on it. So when they transferred it, the lien was gone. That's why when you guys file that UCC 11 and you do your search and you see ain't no liens, because the moment that they transferred it, and I showed y'all under SBG Global how they transfer, the moment they transferred that title to another agency, there is no more security interest, because only the original creditor can put a lien on you. That's why nobody has a lien on any of their stuff. If I was you, I would make sure that when you are getting your settlement, you tell them that they need to go on your credit report and say that all payments was paid as agreed and paid up. Do not get it taken off, because you need your credit, because remember, you got to live public and private. Okay. So that is the arbitration class. I will send out both videos at the same time so you will have both parts. Because now I feel safe that if you do decide to do arbitration, that you're not running with your chicken with your head cut off because you didn't overstep your boundaries. So that it is, I do things for a reason. It's not because I'm like, oh, forget them, I'm not going to get on the replay. No, because I can tell you that 90% of y'all was going to go try to hit them buttons like do real quick. And then you would have been lost without the second part. So now you have a whole pie to be able to move accordingly. Get your pills and do not pay, do not collect status. And that goes. And it's so unfortunate because I know y'all got questions and I normally would answer them. But today is called Learn a Lesson Day because Tamika got boundaries. And when you cross my boundaries, that's what you get. So I will get this. This is going to be the easiest one to edit because I ain't got to edit much. And you guys will get both videos. If you guys do need assistance, we are here. But once again, please understand that we are not obligated to answer a DM. We are not obligated to answer a post. We're not even obligated to post as long as I run this class like it's supposed to be. But my little $10.11 an hour, because that's what it look like. That's all that matters. Okay. So on that note, this has been the shortest class in history that I've ever done in my life. But you guys gonna have to learn to appreciate those who really try to help y'all. And on that note, everybody have a good night.